your own to law minstrel. I am Mwisi Modukbe Nyim. Thank you for joining us on another episode in our series on the law as concerns hire purchase agreements. Today on this episode, we'll be looking at termination of hire purchase agreement. Essentially, we'll be trying to look at the ways that the law has provided by which hire purchase agreement may be terminated. Now, of course, everything that has a beginning must have an end. So hire purchase agreement that has been initiated or begun would also have a point of termination, the point by which it is brought to an end. We'll be examining all of these ways today that the law has provided as legal ways by which a hire purchase agreement or transaction may be brought to an end. I'll just pause here and enjoin you to join our community by subscribing to our channel. You'll do this by clicking on the subscribe button down there and clicking on the share button in order to share our channel or episodes with any of your pals, or give us a thumbs up and give us your feedback, which is absolutely important to us in the comment section. I'll be meeting you in the comment section immediately after this video. Thank you. Now, we are looking at the termination of a hire purchase agreement, and there are essentially 6 ways by which a hire purchase agreement may be brought to an end. The first way by which a hire purchase agreement may be brought to an end is by way of performance. The second is by agreement. The third is by breach. The fourth is by exercise of statutory power. The fifth is by frustration. And finally, the sixth is by judgment of a court. We'll begin by looking at termination by performance. Termination by performance is very excellent. Termination by performance means that the subject matter of the hire purchase agreement has been completely performed. You have done everything you are supposed to do peaceably. The hirer has been paying without trouble. He has gotten to a point where he should exercise his right of purchase. He has also exercised that right of purchase. He is now the owner. So the relationship of a hirer and a vendor or owner does not exist anymore. It has thus been brought to an end by due performance of the entire contractual relationship. So an agreement is terminated by performance or brought to an end by way of performance when the parties, that is the owner and the hirer, have both performed all their obligations under that contractual arrangement. So when this happens, the hirer is then entitled to exercise his right of purchase of the goods, which are the subject matter of the hire purchase agreement. The consequence of this is that the hirer then becomes the owner of the goods. The contract is as a result discharged, and no further obligation are attached to the hirer or the vendor or the parties, so to speak, under that agreement. The second way by which a hire purchase agreement may be terminated or brought to an end is by agreement. So when both of the parties come together for reasons best known to them and they dialogue and decide that, oh, we are ready to bring this agreement to an end, we can't go on for so and so reason, and they agree among themselves so to do. Nobody is going to force them. In fact, at the beginning of the contract as well, they were not supposed to be forced. If it was forced, then the contract will be said to have been entered into under duress or undue influence, and it will be unenforceable. The law will protect either of the parties to which the duress or the undue influence relates. So ordinarily, The contract is a contract because they both by agreement entered into it. So by agreement as well, they can decide to terminate the contract. During the continuation of any hire purchase contract, the parties remain free to put it to an end by mutual agreement. Such agreement is constituted in the promise by each party to release the other from his obligations under the hire purchase agreement. A clearest way of doing this is by substituting the existing hire purchase contract with a new one. So the old contract may be discharged expressly by the terms of the new one, or impliedly by the fact of the terms of the old one are now incorporated in the new one, or that the terms of the new one are inconsistent with those of the old one. So you see this on the authority of Abdul Karim versus Incar Nigeria Limited, the citation supplied on your screen. There is also this way of termination, which is by breach. That's the third way of termination we are looking at. So we already said when we were looking at terms of a hire purchase contract that a condition is such a term that when breached, it renders the agreement as though it was never performed. It was never done. It becomes void, and it immediately gives the party towards which that condition was breached the right to terminate the agreement. So a fundamental breach or a breach of a fundamental term, that's a breach of a condition by either party to a contract, entitles the other to repudiate the contract and treat it as though it was not done at all. He can now bring it to an end. So such a breach by the owner may take the form of failure to comply with any of the implied conditions under Section 4 of the Hire Purchase Act. In addition, a breach by the owner to carry out any of the statutory formalities under Section 2 may, in consequence, determine or bring the agreement to an end. So in the case of the hirer, such a breach may take the form of, say, A, renunciation of his obligations under the contract by evincing an intention not to perform or continue the performance of the contract. Then 2, his failure to pay installments or do so in accordance with the terms of the contract. Then 3, failure to carry out any other fundamental obligation as laid on him under the hire purchase agreement. And you see this on the authority of Amuson and another versus Bennywood Finance Nigeria Limited, the citation supplied on your screen. We go to number 4, which is termination by exercise of statutory power. So this, from the name alone, shows that it has nothing to do with either of the parties per se. It's not a direct act of the parties. It is the exercise of statutory power that brings about, that is the exercise of the power embedded in a law related to the hire purchase agreement. It's the exercise of such a power in such legislation that brings the agreement to an end. So Section 8 of the Hire Purchase Act confers on the hirer an indefeasible statutory power to terminate the agreement at any time before the final installment falls due. It thus follows that if the hirer exercises his right and does so in accordance with the provision of this section, he puts an end to the contract thereby. So this section, however, places on the hirer who so elects to terminate an agreement certain liability. Again, any provision in the agreement whereby this right of the hirer to terminate is excluded or restricted is made void, and so pursuant to Section 3 of the Hire Purchase Act. We'll go to number 4, which is termination by frustration. The general common law doctrine of frustration also applies to hire purchase agreement. So if without default, frustration means that without default of any of the parties, the contract becomes frustrated or becomes impossible to be performed. The parties are discharged from further obligations under the contract because without any of their fault, conditions have rendered it impossible to perform such a contract. For instance, persons are party A and B are in a location, say called Inyofoworogi, and then war breaks out in that location when they had a hire purchase agreement between two of them, and everybody has now left that location. That war that has broken out has frustrated the continuation or the performance of that contract, because a party cannot stay in a location where his life is at risk simply because he has obligations under a hire purchase agreement to pay somebody. Even you, who is the owner of the goods, will not stay. You will not stay because you want to collect money, that installments that are remaining. After all, it's persons that are alive that will perform a contract. So without knowing, without thinking, even giving a thought to that agreement, they are likely going to run out of that location. That type of circumstance is a circumstance that frustrates the performance of that contract, and it discharges them from the obligation to actually perform that contract. So frustration may be by loss or destruction of hired goods, by inevitable accident, by an act of God, or by an act permanently depriving the hirer of possession and use of it, such as by requisition by government under statutory power. See the case of Bentworth Finance Nigeria Limited versus Alhaji Sani Bakori. You will see the citation supplied on your screen. In this case, the subject matter of the agreement, a motor vehicle, was involved in an accident in which it was damaged beyond repairs. The court held that the hire purchase agreement was frustrated. See also Dragitanus Construction Nigeria Limited versus Fabmadis Ventures Limited. You see the citation also supplied on the screen. We'll now look at the sixth and final way of terminating a hire purchase agreement, which is by judgment of a court. A court may give a declaration that the failure of an owner to comply with any of the formalities provided under the Act has prejudiced the hirer under the provisions of Section 2(2) of the Act. At the hearing of an action for repossession of the goods by the owner, the court may, under Section 10(4) sub A, make an order for the specific delivery of goods to the owner. Also, upon completion of payments pursuant to a postponed order for specific delivery under Section 10 sub 4B, the title to the good becomes vested in the hirer. Thereupon, the agreement presumably comes to an end, and the parties discharged from further obligations under such contract. The result is the same, where the hirer, having defaulted in payment after the making of a postponed order himself or his guarantor, pays the whole of the unpaid balance of the hire purchase price, and thereby causing the owner's title to the goods to vest in the owner and in the hirer. You will see this on the authority of Section 12B of the Act. So, in sum, termination by a court order is what the name implies. Termination by judgment of court is what the name implies. It is not the parties that declare or bring the hire purchase agreement or contract to an end, but it could be brought, an action by one of them can be brought before a court, and the court, having listened to any of the parties upon the grounds that are provided for under the act, will now pronounce that hire purchase agreement or contract to have been brought to an end. So when it is a court that declares it to have been brought to an end, you now say that such agreement or hire purchase contract was terminated by a judgment or order of court. With that, we have come to the end of the 6 ways by which you can terminate a hire purchase contract. We'll just do a rundown of those ways again for the purpose of having them stick better to our memories. And the first is termination by performance. Then the second is termination by agreement of the parties. The third is termination by breach. The fourth is by exercise of statutory power. The fifth is by frustration. And finally, the sixth is by judgment of court. Thank you so much for being with us again in this episode. And I will remind you again, if you have not done so earlier, to kindly support us on this channel by clicking on the subscribe button. Thank you. And sharing this video and others with others. And giving us a thumbs up. And finally, meeting me in the comment section. I want to get a feedback from you on this video. Did you enjoy watching this video? Did you not enjoy watching it? Is there something else you want us to do a video on? Meet me in the comment section. Till next time, I am Mwisi Modukbe. Thank you.